So mediation is an opportunity for two people who completely disagree about something that has to get decided to compromise with the assistance of someone who is extremely skilled at assisting people who no longer see one another's perspectives to roll it back and see the other person's perspective so that they can meet in the middle and find a way forward that isn't exactly what they both want, but it works. Mediation is an opportunity for spouses to decide how they're going to divide things up, the decisions they're going to make around children for themselves. Litigation is what started this whole thing, right? Somebody filed the petition, we're in litigation. Mediation is an opportunity within it to resolve something. If you don't, litigation is the course of gathering evidence, taking deposition testimony, finding out like whether or not we need particular experts in a case on economic issues, business valuation issues, real estate valuation issues, all the things. And then you're going to end up in front of a judge in family law. And that judge is going to see you for only a certain period of time. They will likely know very little about you. And based on the law and the law only, not what you know about one another, not the hopes and dreams that you once held in common that you could resolve, that you could take into account at mediation, but just based on the statute, the law, the case law that says XYZ about your particular set of circumstances and the law. That's all the judge has to go on. Then their universe of factors that they can use to decide the issues in your divorce are limited to the universe of statutes and case law. That's it. So the way that litigation is different than mediation is that you are taking away your own power of choice and giving it to a judge. So no longer are you in control of how these issues are going to play out after you are divorced. All the money, all of the child rearing, all of that is going to be given to the judge who's going to control those decisions based on the law. And that's it. You have no say. You're giving up your power of choice. Mediation, power of choice. Litigation, no power of choice. The cost of mediation is significantly less than the cost of litigation. So let's do the math, because I often hear this from clients who are upset that, well, she's paying her attorney and I'm paying you and we're paying I'm paying half the cost of the mediator and she is too. And that's a lot of people in a room to get all paid in one day. It's a big bill for one day. Well, is it? Because if you can in one day walk out with a solution that you can both live with, maybe you don't like it, but you can both live with it for a certain amount of money for the three people to be paid for that day versus litigating it all the way to trial, which is going to take months, by the way. So we're talking probably 6 to 8 months from mediation before you are likely going to get on a trial docket. And that means in the interim, there are certain procedural requirements to make it through that courtroom door on that day of trial that you're going to have to gather evidence. You're going to need to take depositions potentially. You might have to pay for expert witnesses. Let's say you have an expert witness. Each expert witness is going to require their own retainer and they have their own hourly rate. So we are just aggregating, stacking upon stacking, cost, time. The longer it drags on, the more costly it gets. And then at the end of it, you're left with something that probably neither of you want. So you've got to go to mediation in almost all family law cases in Florida. Almost all of them, certainly in divorce cases, you're going to be required to go to mediation. So when does it not work? Because you've heard me say, hey, this is your best shot at getting what you want. But it doesn't work if you're not prepared for mediation. If you go in and either of you does not have transparency and visibility into the value of your marital estate, if you don't have thoughts already down in paper about what you want to do on a parenting plan, time sharing, if you haven't already calculated alimony, if we don't have financial affidavits, if no one has exchanged mandatory disclosures, which is how you get visibility into the value of the marital estate, if none of that's been done, we're going to go in and we're going to just be, pulling ideas about how to do this out of the air, and they're not going to have legs. They're not going to mean anything, and neither party will feel comfortable with it. So it'll fall apart. The other way that mediation can truly fall apart and not work is if somebody comes in and they've already decided they're not compromising on anything. They're going to fight. That's it. Or we've seen it where we've seen a party and an opposing counsel come in, sit down in mediation, and stay for 15 minutes to say that they checked the box and that they mediated, and they didn't. But they've checked the box. All that is required is that they show up. So those are really the scenarios in which it doesn't work. One of the reasons you want an advocate with you by your side at mediation is that a good advocate, a good attorney, is going to walk you through how to prep for mediation so that you are going in with eyes wide open and the ability to make an informed decision about whether or not to resolve everything in one fell swoop at mediation. We can be that advocate at Brava Law. Give us a call today for a consultation.